Hi, this is Kid Malek from Malek and Malek. I am today out in a park. Um, Today I'm going to be talking about information and your workers' comp claim. And what I mean is I'm going to give some examples, and all these examples and issues that I'm bringing up have occurred in relation to a either hearing or a lawsuit that I've had in the past. So these are real life things that have occurred that are relevant, and I think it's helpful for you to know about this. Hopefully the birds don't drown us out, but I apologize if the birds are too loud. But like I said, I'm in the park, so I can't control that. It's kind of nice out. This is a park kind of in the area where I live, so I don't think there's anybody here, so it's kind of nice. But okay, so what do I mean by information? Okay, the first thing I mean with information is describing how you were injured when you go to the hospital or urgent care or the workers' comp doctor. So you want to be specific, but you also need to be careful that you're not too specific. And what I mean by that is certain injuries require certain things to happen for that injury to be supported. For instance, if you have a meniscal type injury, the doctor is going to be looking for a twisting and turning. If you describe something and in the initial records and it doesn't involve twisting or turning with your knee, and you're very specific about, well, I just hit my knee on this pole, and then you're going to try to get a meniscal tear, what they're going to say is, yeah, this guy had a contusion, but there's no twisting or turning, therefore it's unlikely that this meniscal damage that may or may not be visible on the MRI is related to that particular injury. It might be that that's age-related meniscal degeneration. Also, every little bit of information that you give, that you reveal, is a potential thing that the employer can use. They could find some twist or turn to manipulate that information to deny your claim. So for instance, if you're moving furniture in your office, and then you hurt your back and you're moving, I think it would be better off to go to the ER or hospital and say, hey, I was moving this couch and then I felt lower back pain. It explains what happened. It explains what you were doing, and then it explains when exactly it occurred. And then what that allows you to do is, so when you go to the industrial commission hearing, if the claim is either denied by the BWC or there's an appeal by the employer to deny the claim, is that gives you opportunity to explain what happened at the hearing, and then that testimony will come out in the hearing rather than the testimony occurring or the interpretation of the nurse or doctor, whoever wrote that mechanism of injury down in the medical records. So you're not fighting against what the nurse wrote or the doctor wrote in the ER visit records. So be specific, but don't be more specific than you need to. Also, you got to be careful in this regard, because especially if there's like any kind of post-accident investigation that occurs, and let's say there's video footage, surveillance footage, and you're saying, and you're dead to rights sure that you fell on your back and that's how you got injured, and then they reveal footage and something happened, there's a physical action that occurred, you're involved in some kind of physical thing, but you didn't fall on your back. So because what you described happened doesn't match the video footage, I would argue you were involved with some kind of physical incident, but the hearing officers, they might fixate on, well, this person's not credible, and maybe they got injured somewhere else because the video footage does not reveal that. So you gotta be careful what you reveal. The other thing is, you don't want to, especially if there's video footage, you don't want to look like you're exaggerating or like blowing up. And this happens like if you're saying, I was hit by this massive box, and you tell the doctor it weighed between 50 and 80 pounds. And then the employer actually produces information that, well, guess what? The box weighed all of a pound. And then they have video footage, and it's like a styrofoam box. It just doesn't look very credible. I mean, I question how you'd get injured in that instance anyways. But hey, you're the person that got injured. And maybe it's not as silly as that. Maybe it's in the mid-range. But again, if you say one thing, if what you're saying doesn't match up with objective information that they have, either through surveillance footage or the medical record that you record, that's gonna be a problem for you in regards to your claim. So be careful with information. The other thing is be cognizant of what you're telling your coworkers. If you're gonna say, at the hospital or to the BWC doctor, oh, I've never had issues with my neck or my lower back, and then you go ahead and you've been talking to your coworkers and you're like, man, my back hurts, and you're talking about this, and then the employer is going to bring these coworkers and be like, yeah, this guy's always talking about his back hurting, and then you're gonna testify, I've never had back issues. They're going to have these witnesses, or it's going to be in your medical record that you had back issues. That's going to be a problem. So keep that stuff to yourself. I mean, frankly, my advice to everybody is keep your personal business to yourself in relation to anything. It's fine to talk with people at work, but more likely than not, when things go sour, the information that you revealed is going to be used against you in a detrimental way. So you need to be cognizant of what you're actually revealing. Now, another thing that I'm going to talk about is, in terms of information, is if you're posting to social media and you have some kind of lawsuit, some condition in court, and particularly if you have a site condition. So if you have a site condition and you're posting to like Facebook, and you've undergone the psych eval, and at the psych eval psych evaluation by both our doctor and the BWC or the employer's doctor, you testify, I'm really sad every day, I cry, my activities of daily living are severely impacted by this work injury, I can't do the things I used to do. And then your posts on Facebook to your friends, and you're making this stuff public. And frankly, even if it's private, I'd be concerned if you're posting this, because some of these things are discoverable, i.e. they can request copies of this information. But you post, I'm having my best life, or you go to the vacation, you're all smiling and happy, and you're taking all these pictures. I just be careful about that. Think about what you're doing, and think about what's going on. And frankly, if you have anything in court, or if you have any legal issue, I would curtail using social media. Don't delete your social media accounts. Don't delete your posts. If you do that, you could be found to be destroying evidence. But I would just curtail the information you're revealing in that regard. So that's in relation to that. The final thing I'm going to talk about, and again, all these things impact because I've had clients that post things to social media and they've been used against them. I've had clients describe their mechanism of injury in great detail, and then there's surveillance footage that doesn't quite line up with what they're describing, and that's been used against them. The final thing that I'll talk about is if you're going to, I suppose if you're retiring, it's a little bit a different issue, but if you're going to resign or quit and you have another job lined up, it might be better just to go to that next job. Start the next job day one, you're working there, everything's great. Call up your old job and say, hey guys, FYI, I'm working over here now. And the reason why I'm saying that is this has come up too recently, where somebody, and this happens, I mean, there's hearings, you could look up commission orders where this happens enough where it's an issue, where people give notice of resignation and then 2 days before they're supposed to quit, they get injured. Well, what do you, if your plan was to go work at some new job, or your plan was to wait a month and work at a new job, what you've done now is basically the employer is going to argue this concept of voluntary abandonment, which has been superseded by changes in the Ohio law, but they're still going to argue it. And frankly, the changes that have been made to the Ohio law, I think, are more, this is 412356F. I almost think they're going to be used more often against the injured workers than as a thing to help them. But the idea of voluntary abandonment is you do something that disconnects you from your job. So your work injury didn't disconnect you from your job. Your voluntary action. So that could be, you do something like you flip somebody off, or you curse at somebody, or you give notice that you're going to leave the job. And so they could interpret that notice of resignation as, hey, he intended to leave the job, he voluntarily abandoned the job. Because he voluntarily abandoned the job, he's not entitled to comp. So this came up in the hearing, and what ended up happening was we had to go into great detail about how this guy had another job lined up and how he was planning on starting. And unfortunately, he had a piece of evidence that we could use to substantiate what he was saying. But if he didn't have that, then it might have been a harder road to hoe. Especially because bottom line is, just think, if you really feel it's necessary to give notice that you're going to start somewhere else, go ahead. But also realize that you may be negatively impacted by that notice of resignation. I'm not sure you really gain that much by giving notice. I think there's a limited number of jobs where you're actually required to, but I think most at-will employment jobs do not require notice of resignation. And if you give notice of resignation, you're not getting anything for giving that notice. I mean, I guess, if in the future, if somebody calls that job for reference, you could say, yeah, he was a good guy. If that's worth it for you, then by all means give notice. But if you have a lukewarm relationship with the job, and just weigh the benefits and the negatives, because it could be one of these situations where you end up getting hurt, before you actually get into your new job. So with that being said, this is, you've been listening to me, Kip Malek, from Malek. If you have any questions, concerns about anything I've talked about or any other issue, go ahead and either post them in comments or give our office a call. If you've had a work injury and you need an idea, or you're not sure what you need to do, or if you need to get an attorney, give us a call. We'll give you an honest assessment of whether or not you should get an attorney. If we really don't think you need one, then we'll let you know. If we do think you need one, we'll let you know as well. Otherwise, get outside. It's nice out. It looks like right now it's sunny. It's been cold and snowy these past however many months, so we're finally in summer. And otherwise, have a nice day, and I hope you're doing okay, and we'll hear from you later.